Welcome back to today's Explainer, everyone. So today we're going to unpack one of the absolute most brilliant and honestly most consequential legal fictions in all of American constitutional law, Ex Parte Young. If you really want to understand how the supremacy of the U.S. Constitution is actually enforced on the ground, this 1908 Supreme Court case is your definitive cornerstone. Think of this as a masterclass in constitutional litigation. We're going to dive into how a high-stakes standoff between railroad stockholders, a very defiant state attorney general, and the federal courts birthed a procedural workaround that literally reshaped the balance of power in the United States.
Here's the syllabus for our analysis today. We'll be covering the strategic legal context, the factual foundation of the Minnesota rate statutes, the necessity of equity, the famous stripping doctrine, and we'll wrap up with the contempt sequence.
Starting with Section 1, Strategic Legal Context, the Constitutional Paradox. Now, as you'll likely remember from your foundational con law studies, the 11th Amendment broadly protects states from being sued in federal court without their consent. It's a massive, fundamental pillar of state sovereign immunity. You can't just drag a state as a whole entity into federal court to answer a lawsuit. And the idea here was to protect the dignity and, frankly, the treasuries of the states within our federalist system. But as we're about to see, this creates a rather massive structural problem when a state decides to act outside the bounds of the federal Constitution.
I really want you to consider this impossible catch-22 for a second. If a state legislature passes a law that blatantly violates the U.S. Constitution, let's say by confiscating private property without due process, how can federal supremacy actually be maintained? I mean, if the state is entirely immune from federal lawsuits, who exactly do you sue to stop the unconstitutional law from being enforced? You can't sue the state itself, so what's the mechanism? Keep this huge paradox in the back of your mind as we look at how Minnesota decided to test these exact limits.
Moving right along to Section 2, the factual foundation, the Minnesota rate statutes.
Let's look at how this played out chronologically on the ground. Between late 1906 and early 1907, Minnesota went on the offensive and aggressively reduced railroad rates across the board. First, in September 1906, a commission order severely reduced freight rates. Then, on April 4, 1907, the Passenger Rate Act slashed maximum passenger rates down to just 2 cents a mile. And barely 2 weeks later, on April 18th, the Commodity Act drastically lowered rates for transporting specific goods. The railroads basically said, hey, these rates are so low they're entirely confiscatory, you're depriving us of property without due process. Facing total financial ruin, on May 31, 1907, which was literally the very day before the Commodity Act was set to take effect, frantic railroad stockholders filed 9 federal equity suits.
But here is where the state's strategy gets incredibly coercive. The state legislature purposefully engineered these terrifying, accumulating penalties to create a massive chilling effect. They explicitly wanted to intimidate the carriers from ever daring to test the validity of these laws in court. We are talking about everyday ticket agents facing 5 years in a state penitentiary just for charging standard rates. Violating the September order? That was a gross misdemeanor carrying fines up to $10,000 per offense. These escalating draconian risks were designed to make quiet compliance the only survivable option.
Which brings us to Section 3, the necessity of equity, evaluating legal remedies.
These terrifying penalties perfectly illustrate the totally impossible dilemma the railroads were boxed into. Look at option A. Simply comply with the unconstitutional statutes, swallow the confiscatory rates, and suffer a slow, agonizing financial death. Or check out option B. Disobey the law for the sole purpose of testing it in court. But choosing option B meant triggering those draconian penalties we just talked about, risking total asset confiscation for the company and long-term imprisonment for its directors and agents. A legal system that forces you to risk 5 years in prison just to get a hearing on your constitutional rights that is fundamentally denying you the equal protection of the laws.
Plus, waiting around to be criminally indicted just to raise a constitutional defense was declared an inadequate remedy at law. Why? Well, the Supreme Court pointed out that an ordinary criminal jury is simply not equipped to intelligently pass judgment on the insanely complex math and economics required to figure out if a railway rate is actually confiscatory. Let's be honest, asking an everyday jury to do complex algebraic economics while simultaneously weighing constitutional theory? Yeah, that's a recipe for disaster. That kind of deep, granular financial analysis requires a court of equity, utilizing expert opinions and referring matters to a master to make those complex computations. So raising a defense at a criminal trial was simply not a viable path to justice.
So federal courts had to intervene, bringing us to Section 4.
the stripping doctrine, severing the officer.
To logically bypass the 11th Amendment, the court established a brilliant workaround. They ruled that a federal court can successfully assert jurisdiction over a state official if, and only if, these three strict requirements are met. First, a federal question. There has to be a genuine challenge that the state action violates the U.S. Constitution. Second, a connection to enforcement. The state officer being sued must have some duty to enforce the act. The court actually clarified it's immaterial whether this connection comes from specific statutes or common general law as long as the duty's there. And finally, the unauthorized act. The threat and enforcement must be an illegal act performed without valid state authority.
And here is the absolute genius of it. The crucial point is captured beautifully in this quote. By declaring that an unconstitutional law is inherently void, the court elegantly concluded that the official attempting to enforce it cannot possibly be acting on behalf of the state. Right? Because the state, as a sovereign entity, cannot authorize an unconstitutional act. Therefore, the official attempting to enforce it is acting individually. He is conceptually severed and, in the court's exact words, stripped of his official character. This is an absolutely brilliant and almost absurdly convenient legal fiction. Because the officer is now viewed as an individual wrongdoer rather than an agent of the state, poof, the 11th Amendment immunity just disappears. The procedural path for equity is fully cleared.
Which leads us to our final part, Section 5, Procedural Supremacy, the Contempt Sequence.
Now, this stripping theory wasn't just some fun academic exercise. It was immediately put to the ultimate stress test in a high-stakes jurisdictional game of chicken with Minnesota Attorney General Edward T. Young. On September 23, 1907, the Federal Circuit Court issued a preliminary injunction specifically restraining Attorney General Young from enforcing the April 18th Commodity Act. Well, in open defiance of this federal order, Young marched straight to a state court the very next day, September 24th. He secured a writ of mandamus from the state court, attempting to legally compel the railroads to comply with the exact same act the federal court had literally just enjoined him from enforcing. It was a direct, lateral maneuver to just completely bypass the federal judiciary.
While asserting procedural supremacy, the federal court forcefully responded. They hauled Attorney General Young back in, held him in contempt of court, and fined him a grand total of exactly $100. But, way more importantly, they handed him over to the U.S. Marshal until he dismissed the state proceedings he had just initiated. I mean, throwing a sitting state attorney general into federal lockup over a $100 fine is highly dramatic, but obviously, this wasn't really about the money. This was a profound assertion of federal judicial power. The federal court was stating in no uncertain terms that once it takes jurisdiction of a constitutional question, it has the absolute right to decide it to the exclusion of all other courts.
So naturally, Young appealed this contempt charge all the way up, arguing the federal court had zero jurisdiction over him. But the Supreme Court firmly upheld the contempt citation, and they made a really fascinating distinction here. They noted that while a federal court generally cannot issue an injunction directly against a state court, it absolutely can enjoin the state officer from initiating proceedings in that state court. By upholding this distinction, the Supreme Court decisively shut down the ability of state officials to use these sneaky lateral maneuvers in state courts to circumvent federal constitutional inquiries. Checkmate.
As we wrap up today's explainer, I want to leave you with this final provocation. Ex parte Young remains the indispensable tool for constitutional litigation to this very day. By allowing plaintiffs to seek prospective injunctive relief against state officials, it ensures that states cannot just hide behind sovereign immunity while violating the constitutional rights of their citizens. I want you to seriously consider what the balance of power in the United States would look like today without this essential legal fiction keeping state power in check. If you couldn't sever the officer from the state, federal supremacy would be nothing more than an empty promise. Keep that in mind for your final exams. Thanks so much for joining me for this explainer on Ex parte Young. See you next time!